Hi, welcome back to Space Thoughts. What we're going to talk about today is a topic called Lawfare. Now, I've talked about Lawfare here off and on in some of these videos. I do a lot of it with my writing. I have a section on Lawfare in my briefing letter, the Pressy. But what I want to do today is actually talk about what Lawfare is and how it applies to outer space. Now, in doing this, I'm going to break this down into two separate videos. Today, we're just going to talk about Lawfare as a concept and what it entails, what it is, and what it's about. And in the second video, we'll go right to outer space and give some examples that are specific to outer space. Now, I've done this before. About a year ago, I think it was back in February 2020, I did this presentation on Lawfare for the space show. So if you want to go to the space show and listen to that show, that's always a good one. In fact, I'll leave the link down in the bottom here afterwards. But I've also used it for a conference called Ascend that I did back in November. I did a variation of it. So what I'm going to do is take slideshow that I did for both those and kind of do a variation of it to explain this. So I'm going to break it up. This will be the longer of the two videos because we're going to be exploring the whole topic of what Lawfare is, its history and whatnot. And the second video will probably be a little bit shorter because we're going to talk about space-specific examples that are going on right now. So I want to talk about this because this is a very real thing right now. It's a very important critical issue that really has to be looked at and understood, that hey, this is something that's actually out there, that's actually happening, and law is being used in this way. And I'm going to preface this by saying one thing. I've always looked at law as being an adversarial pursuit. I mean, I've had arguments or conversations where people say, well, law isn't, law is about getting people together or making law and things like that. And yeah, that's part of it. But inherently, at its root, law is an adversarial pursuit. When you represent a client, whether it's a private person, a corporation, or a state, a geopolitical state, you are basically representing their interests, and you're not representing the other side's interests. So it's adversarial, and this is where Lawfare kind of all plugs into this. In law school, I was always my whole impression was, I'd sit in the law library studying and have all these books surrounded around me, and people would say, well, why you spend so much time here? I said, because I'm surrounded by the law, and the law is a tool, and if necessary, I can use law as a weapon to reach an end that I want to reach, and that's basically what the whole idea of Lawfare is, as we'll see a little bit further. So understand, this all comes from the perspective that law is an adversarial pursuit, and that's just what it is at its nature. So again, this is the first part of it, and we're going to talk about law. We're going to talk about Lawfare in terms of its general concept, and in the second one, we'll talk about outer space and Lawfare in particular. Before we get into what Lawfare is, we got to really dive into the two worldviews of international relations. And I want you to understand that when I'm talking about Lawfare, I'm talking about relations between nation states, geopolitics, how states interact with each other. There were two gentlemen who basically had two different views of the world, and they lived around the same time period, as you can see by these dates here. But we have one gentleman by the name of John Locke and the other of Thomas Hobbes, who really had two opposing views. John Locke was basically of the opinion that the states will apply and abide by the rule of international law in their relations. In other words, if international law is agreed to, this is nations will abide by it in their relations, and everything will be great, and they'll settle the disputes according to the law. And that was it's a very legalistic saying, the rule of law, what we call the rule of law, and that we see that applied a lot today when we talk of international relations. We talk about the rule of the rule of law, the rule of international law in particular. Thomas Hobbes, on the other hand, was kind of had a different viewpoint. He was basically saying, when it comes to international relations, the rules sometimes, they either get bent or ignored, and basically it's about what I call the law of the jungle. In other words, in order to reach an end, geopolitical rivals or geopolitical actors, state actors, will act will basically do whatever they need to get the end that they want. It's basically the end justifies the means. So you have the Lockean view, which basically says, rule of law, abide by the rules, stick to the rules, and you have Mr. Hobbes, who basically says there's no holds barred, it's a law of the jungle out there, and that's the way the world is. So, and I'll show you how this all fits into the idea of Lawfare in a moment. So the concept of lawfare is actually a fairly recent one. I think it's only like maybe 20 years old. The actual term is only 20 years old. But the whole idea of lawfare, the whole concept of lawfare is actually a lot over. And really, I think it originated back in 1609 with Hugo Grotius. And I'm sorry if I'm mangling that name for my friends in the Netherlands. But basically, he was considered the father of international law. And he basically wrote this thesis called Mare Liberum, which means free seas. So basically what Mare Liberum is, if you get the book, you can still order the book today and look at it. It is one long legal argument, one long legal dissertation for that this gentleman proffered back in the 1600s. So fundamentally, all this came back to the oceans. Now, back in these times, space was not something we even considered. We looked up in the skies and we saw the stars, and that was about it. And we wondered at the stars. The real area of contention was land, but most importantly, the sea. And this is where Mare Liberum comes into. Fundamentally, the problem was this: Netherlands wanted access to the East Indies, and a lot of these trade routes were already established by previous explorers, like Portugal. And through what we call the discovery rule, Portugal basically made the claim to these sea lanes in the open seas, saying, you know what, these are we discovered them, these are ours. And there was a lot of political support behind that, especially from the Roman Catholic Church and papal jurisdiction. In other words, the church had a lot of political influence back then, and basically said, we support Portugal's claims to these. They discovered them; it belongs to them. You, the Netherlands, can't come in. Now, the problem was because of this idea that the Netherlands wanted to be able to use these routes. The question was, how are we going to get these? Well, one of the traditional ways is to go to war. You marshal your military forces to have a hard power response to a geopolitical rival in order to reach a political end. In this case, the political end was to have free access to the oceans. But the Netherlands really wasn't a large player in terms of militarily back then, especially compared to Portugal and other powers like Spain and Britain. So really, they were at a point where they couldn't challenge these sea powers militarily in order to reach the end of getting open access to the oceans or these trade routes to the east, to the Indies for trade of spices and such. So basically what Grotius did is he created a legal argument in Mare Liberum that basically was an argument of natural law that basically says the seas don't belong to anybody in particular, including those trade routes that were discovered by Portugal, and basically they are open to everyone. And he made this argument before a large international body at the time, and international was pretty much what we call the old world nowadays, and asserted that, you know what, according to natural law, the oceans belong to everyone, and there's this idea of free access. There's no such thing as universal no idea of one nation can basically claim universal jurisdiction over the seas. So he made this argument, and he actually made it quite successfully. And from that, we have the idea of what we call free access to the open seas, and we still enjoy that today. And of course, now it's codified in the law of the sea, although not all nations ascribe to have signed the law of the sea, but still, that is basically formed a customary law or customary norm of international law that there is free access to the oceans. So what Grotius did is basically, instead of the Netherlands using hard power, military force to achieve a political end of this open seas idea, Grotius used legal force. He used what was called law. It wasn't called lawfare back then, but basically what he did, he basically used lawfare. So in essence, Grotius did two things. One, he created the idea. He was basically the progenitor of international law, but he was also the progenitor of the idea of lawfare, even though we didn't call it at that time. So understand that idea, that action of arguing before all these nations that argue national law that the oceans belong to everybody. He basically established a principle of international law that we still enjoy today. So what is lawfare? And again, like I said, lawfare as we'll see in a few moments, is a very recent term. But lawfare is the use and tools of institutions of law to further the interests of states and effect change in the international arena that otherwise might require the application of military force. It basically is lawyers using legal arguments or creating legal ideas and bringing them into being in international law to achieve a political end versus using hard power. Lawfare has its tools, has its weapons, so to speak. It employs treaties, customary international law, norms, domestic legislation, domestic policy, and non-binding international measures to achieve its goals. It basically, lawfare can be used both in an international venue and also domestic venue. For example, you can argue an international matter in the domestic court of a nation. For example, the federal courts of the United States have jurisdiction over matters between that are exclusive to the United States and other countries. They can hear those cases and they can decide those cases and actually render a legally binding judgment. Lawfare is employed by governments, private attorneys, and non-governmental organizations, what we're going to call NGOs, including groups identified as terrorism groups. So in other words, this is something that is used by multiple, in a wide breadth by multiple actors, and it basically isn't used not only to gain an advantage, not only to say gain a right like free access, but also to prevent an adversary from utilizing hard power, for example. And we'll kind of show that a little bit more as we go along here. Lawfare can be applied in all international domains, including land, sea, air, cyber, and outer space. Again, we'll talk about outer space more in the second part of this video, but I want you to understand that this is anything that does with international lawfare can be very much applied to. Lawfare is unconventional asymmetric warfare. When I talk about asymmetric warfare, I mean non-traditional warfare using unconventional means to to basically reach your military objective or to achieve a political end. Well, I'll discuss this a little bit more in the context of the People's Republic of China, who are very masterful players and users of lawfare. The term lawfare is often misused to describe the use of law to achieve domestic, political, or private objectives, but is not analogous to the true concept of lawfare that focuses on matters of international law in the geopolitical arena. I see a lot of use of lawfare, for example, if you use it in civil courts, or you can be used as a political weapon as well domestically. I really think in that case, yeah, that might be lawfare, but really understand that when I talk about lawfare, we're talking about the use of the law to achieve by states to achieve geopolitical ends, not domestic ends. So fundamentally, the whole idea of lawfare, what is the objective of lawfare, is basically can be summed up by Sun Tzu, who is basically a masterful Chinese general who, before China was actually unified, basically created these precepts of war that have been handed down, have been studied by military tacticians and strategists worldwide. It's actually required reading in most cases. The Art of War is still available, obviously, and it's a pretty fascinating read. But one of the precepts that Sun Tzu had was the supreme art of war is to subdue the enemy without fighting. This is what lawfare does, and this is one of the objectives of lawfare, is to say my enemy may have greater hard power than I do, but through the creative use of the law, through lawfare, I may be able to prevent my enemy from using to applying that force, to apply that actual hard power, that kinetic force, and therefore I can win without having to fire a shot, or without having to fire as many shots as I need to. I can use the law to basically stymie their efforts or curtail their efforts and gain an advantage from that way. Now understand, the whole idea is, and we'll discuss this a little bit further in this video, is that just because an adversary may hold one of their adversaries to the law doesn't mean that they're going to apply the law as well. And that's another creative use of lawfare. So the term lawfare was coined by, he actually retired as General Charles Dunlap Jr. Basically in this thing called Law and Military Interventions. It was an article that he wrote, and this is where basically the term lawfare was first coined and defined. And General Dunlap basically defines lawfare as a method of warfare where law is used as a means of realizing a military objective. And that was back in 2001, so effectively 20 years ago. So I read this, I looked at this definition, and it's a good definition, but it really isn't complete. And I've really toyed around with it a lot and thought about this in the aspects of Sun Tzu. And in regards to Sun Tzu's precepts of winning the war without fighting, this is probably a very good definition. However, if you apply Western military thought, in particular Karl Clausewitz, who you apply his teachings, this definition of lawfare needs to be expanded, and I've done that with my definition of lawfare. My definition of lawfare is as follows: to employ the rule of law and its instruments to augment or replace physical force to serve a national interest or achieve a political/geopolitical end. So fundamentally, what you got to understand the difference between Clausewitz and Sun Tzu. Sun Tzu's basic viewpoint was that once the sovereign or the political leader tells the general to go and prosecute a war, the politician or the sovereign is out of the equation. The sovereign can't say anything else. He or she has to basically stay off to the side, and the general can prosecute the war at will in any means they deem necessary. So in other words, Sun Tzu's viewpoint is essentially no political intervention. Once I get the go word, the politicians are out of it, I go fight the war. Clausewitz, on the other hand, understood that the battlefield is very changeable because politics are always in the equation. The military is always subordinate to the political leaders, and the political leaders can change their minds. So in other words, when the political leader actually goes to gives the orders to the generals to prosecute a war, they do so at the discretion of the sovereign. In other words, the sovereign can change his mind, can basically put limitations on what the generals can do. But I think fundamentally the big difference between this definition and the one General Dunlap made is that war in itself is not military. Wars don't have military objectives. They have political objectives. In other words, the military prosecutes political objectives. So again, I like this one a little bit more because it fleshes out the nature that basically the teachings of Clausewitz and the understanding that the sovereign is always involved in military decisions, or is always in the picture when military actions are being prosecuted, and the fact that really military actions are not there for a military end as much as but they're really there for a political end. Now, this rule that I've developed is kind of evolutionary. I've toyed with it off and on. I still don't think it's complete, and I'll end up modifying it in the future. But for right now, this is what I consider the definition of lawfare. Again, talking about the international sense. So, the tools of lawfare. In war, you have tools. You have tanks. You have ships. You have bombs. You have munitions. Anything to deliver kinetic force. In lawfare, in the international arena, you also have tools, and in this case, there are 4 basic tools. There are treaties. There's domestic law. There's customary international law and norms, and soft law and non-binding measures. These are, in my opinion, the 4 major, I can say, tools of international law. Treaties. Lawfare uses legally binding treaties in 2 ways. If a treaty is agreed to, a state can interpret the treaty either through pronouncements or practice that can be accepted as international law. Once the rule of law is established, a state might ignore all parts of a treaty but insist on a geopolitical right to abide by the rule of law as set out by the treaty. This could provide a geopolitical advantage to one state by putting the other state into a legal box. Now, when I was discussing it earlier about, one of the practices of the People's Republic of the PRC, and one of their strategies is, if we can ignore the law but make the other side abide by it, that'll give us a military advantage. So we can do that. For example, if there is a conflict, if in a conflict the U.S. has agreed to not use a certain type of munition or not perform a certain action, it'll refrain from that. If the PRC, for example, or the PLA in that case, decides that we know the U.S. will abide by the rule of law, but we won't, and we'll perform this type of action, and we'll take advantage of that, perform this type of action in order to gain a military or strategic advantage. Now, I'm just going to preface this saying, a lot of people are going to jump in and say, well, you're picking on the PRC. I'm basically just calling it like, I'm basically stating to you what is. This is how the People's Republic of China and the PLA basically operates. It's reality, folks. And I'm not making this up to bash the People's Republic of China or any other states that I might bring up. Back to treaties. Treaties can also be used as a lawfare tool to generate soft power, even if a treaty is never adopted. Good example: if I have a treaty for, say, space weapons, and I bring it to the UN, I can bring it in there knowing that there's no way this is ever going to get signed, but I can use that to generate a lot of political power or a lot of goodwill among other nations, and gain a lot of moral authority in the topic by continually promoting on it. In other words, I know the terms will never be agreed to by most nations, but if I can keep this in there enough, I can create enough of a stir where I as a state will gain a moral advantage, and I gain the soft power or political support of other states that may jump on for whatever reason. So that's two-way treaties that can be used. You can use actual treaties, the way you interpret them, or ignore them for that matter, or you can also use draft treaties that never really are going to become law, as a political chip to further soft power in international bodies. Customary international law. I've talked about customary international law. I did a video on customary international law, I believe, last year. Custom is basically international law established by practice, or that is basically accepted as legally binding. The neat thing about custom is a very slippery thing. You can unwittingly become, create custom through your actions, even though you're not intended to. And I think one we'll talk about in the next video is Sputnik, launch of Sputnik 1. I will talk about that later, but the idea is through an action you can unintentionally create an international norm or an international rule that actually benefits another state or strategic goals of another state. Customary international law is opaque and used as a vehicle for norms and non-binding measures to become legally binding. In other words, we see a lot of things about non-binding agreements, which we'll talk about in a bit. The big thing is how these aren't legally binding, and they're really actually kind of very sneaky. These are backdoor attempts to actually create customary international law, just because the idea of customary international law is a very slippery thing. Norms, on the other hand, norms are very slippery things because they can be conjured out of thin air. For example, if I'm an NGO, a non-governmental organization that has a goal of establishing a certain principle of international law, but I know I can't do it directly through a treaty or even through saying, well, we should think this is custom. I can start a campaign of media, political propaganda, or other means to basically create this idea that there is a norm or a standard of behavior that should be accepted, and as that gains momentum, this norm or this thing that never really exists suddenly takes on a life of its own, to the point where it's actually accepted as a true standard of behavior or customary, and eventually adopted as customary international law. So norms can be very slippery in that really when people talk about norms, they're really talking about they really want customary international law. And same thing with these non-binding measures. And I think one good example of a non-binding measure is the International Code of Conduct, which we'll talk about a little bit more in the next video. So understand, customary international law is really one of the best weapons in lawfare, because it's very slippery, and if you're not careful, practice or an activity that a state performs could be brought into the fold. And again, I'm not going to go into the details of customary international law, because I believe I did a video on this, and I've talked about customary international law in some of my other writings. Soft law and non-binding measures. Talked about that briefly in the last slide. Non-binding measures are often proffered as alternatives to legally binding measures. Much emphasis is placed on the non-binding nature of these instruments, but they can be backdoor attempts to use customary international law to make the principles within legally binding. Again, the idea is it's very difficult nowadays to get a legally binding treaty, say for outer space. But there's been a lot of pitches for non-binding agreements, and I think one I mentioned was the International Code of Conduct. Again, we'll talk about it more in the next video. Another thing is these guidelines for the sustainable use of outer space. Even though that that agreement, for lack of a better term, is non-binding and not a legal agreement, it has, the intention is, in my opinion, the intention is to morph that into a legally binding type of arrangement, customary international law, just through practice. So again, these are backdoor soft lawfare attempts or lawfare tools to get to basically put an adversary at a disadvantage. Domestic laws are basically involved in lawfare in the idea that they create basically an environment at the domestic level that allows private actors to engage in lawfare activities. In other words, international relations have nothing to do with are not prosecuted by private individuals. They are dealt with state to state through their diplomatic organs. However, in some cases where the state is basically can't really do anything, through domestic legislation passed by the Congress and signed by the President, signed into law by the President, private entities can go in and attack the situation on their own. I think a good example was there was a bombing of the Beirut Marine Barracks in Beirut back in the 80s. There was really no military response to that, and because of the politics and because of lawfare, the U.S. really didn't respond in the way that in a hard power way, using kinetic force. So a lot of those Marines had families, and basically it was traced back to a terrorist organization that ties to another state. But the state of the U.S.'s hands were tied. There was no way they could get at them. So basically what happened was a law was passed by Congress that allowed private individuals to sue this nation in a personal capacity, get a judgment based on the deaths of their family member, and get a judgment against assets that were frozen here in the United States. And that was highly effective. There was a flurry of lawsuits by the families of these Marines, and they went in and they got judgments, but from the against the state, against this nation, and basically they were granted access to the funds that were held. So in a sense that the U.S. didn't strike back at the state militarily, they did strike back at them financially. Now we hit them in the pocketbook, and that hurts a lot more than it does in terms of political senses. So that's one example where domestic laws can be used to let private attorneys become the legal warriors, for lack of a better term, to go in and actually inflict some sort of harm or some sort of damage on another state without the U.S. having to go in and respond with a kinetic strike or hard power response. Lawfare actors. Okay, basically there are a lot of different lawfare actors. State actors are the number one. In other words, diplomat basically is state to state using international law and using the venue of international organizations to basically prosecute these, to basically gain advantage over other states, and this goes on all the time. I know during the Trump administration there was a lot of actions of lawfare. I'm not going to go through them because I don't want to prolong this video, but there are a lot of good examples of the Trump administration using lawfare to gain a geopolitical edge or to reach a political end against other nations based on that. And some of that we had to deal with sanctions. Basically, states utilize existing treaties and leverage proposed treaties and conventions, soft power and NGOs to achieve national interests. In other words, states may not go in there on their own. They may actually use non-governmental organizations, or basically have non-governmental organizations support their cause by going out there and doing things that they couldn't do, doing things that wouldn't be politically prudent in the geopolitical world, in the international environment. So understand NGOs, non-governmental organizations, they can be kind of the foot soldiers in these types of lawfare actions. And of course, international organizations like the UN and other bodies are really the battlefield for a lot of this lawfare. Lawfare in the international basically in the region form basically uses phraseology as peaceful use and cooperation to gain soft power and shame political rivals. See a lot of use of the world's peaceful use and cooperation in terms of space by our friends in the People's Republic of China. They use it a lot, and most of the time it's just used to basically gain political favor among other nations in the UN, and to basically shame geopolitical rivals. So in other words, when lawfare isn't always designed to really, hit them hard in a military respect, but to do it to hurt them politically, or to basically diminish their another state's political power, or to gain political power on their own, or both. So understand, state actors are the primary actors in this. Academia engages in lawfare, basically through scholarly articles that promote and justify a change to or interpretation of international law. In other words, I could sit down, if I decided this should be, I wanted to create a norm of international law, I could sit down and I could start writing an article about, this is what the law says. And if that gained momentum among other scholars or other members of academia, that would eventually gain momentum. It would reach policymakers and probably start getting implemented. And as it progressed, it may even become customary international law. Thus, through academia, academia has that power to actually do that. And again, in the next video, we'll discuss more of how that's been applied in the context of space, even quite recently. Academia also promotes changes to international law through promotion of formal rules and norms. And basically, the whole idea is the same thing. Okay, basically, somebody writes a paper saying, well, this is a norm. Even though it may not be a norm, they may pluck it out of the air and create it in terms of their article. But on the same accord, if that gets promoted through academia, if a policymaker picks that up, or a legislator picks it up, say, what, we should be doing this, then that may get promoted more in the international community and become customary international law. So understand, academia is also an actor in lawfare. And of course, when I lump that in, I also talk about NGOs as well. So fundamentally, that is the idea of lawfare. And what I want to do, and the last slide here is basically, does lawfare exist? And this is one thing that I have arguments about with people a lot, is people saying, well, you're being paranoid. You're really making this stuff up. This is something that really does exist, and it goes back to the idea that law is an adversarial pursuit. In other words, it's about basically basically representing or advocating for your client, whether your client is a private individual, a corporation, or a state. Or in the case of lawfare, in lawfare, it is basically you're advocating for a state. When you negotiate a treaty, you're not going there to get the best deal for everybody. You're basically sitting down to get whatever you can out of it, while at the same time getting the other side to give up as much as they can too. And that's the whole idea. With law as an adversarial pursuit, you represent your client. You don't represent everybody. So the idea that lawfare doesn't exist is basically not facing reality. And in fact, it as we mentioned before, and as we'll explore a little bit here, it's a doctrine for many states and non-state actors. The PRC, for example, the People's Republic of China, adopted a warfare concept called the three warfares. One of the three warfares is legal warfare, which employs domestic law and international law to further the PRC's interest by asserting the legal high ground. Now, the whole idea is I go in, and the whole idea is promoting this idea. Well, the idea of peaceful purposes and cooperation. The PRC is very good at going in to the UN and constantly promoting peaceful purposes and cooperation to create a high legal standard, a high moral ground, and to gain kind of prestige as being the promoter of that, kind of make it binding. And I've actually seen that done pretty recently too in some other things, which I won't go into right now. But legal warfare can also restrict a geopolitical rival's freedom to operate both military and geopolitically in certain domains and shape operational domains. So in other words, the idea is, if I'm going to start a war with somebody, or if I think I'm going to get into a conflict, if I can use the law ahead of time to get another a political rival or a geopolitical rival to agree to a treaty to restrict their ability to operate, while I at the same time have the intention of not following the rules, That's a big advantage, because if you're going to go, for example, and I used the example before, I agree not to use a particular type of munition. Well, the other side might decide, okay, that's great. We know they're going to abide by the rule of law, but we're not. And we're definitely going to take advantage because it's strategic. It will be a strategic advantage. And understand that this is part of PLA doctrine also. Basically, the idea is if there is an advantage in not following the law, we can basically go, we're going to ignore it if we can get the strategic advantage. And so fundamentally, that's the whole idea. And again, people are saying, well, you're picking on the People's Republic of China. This is reality. This is the real world, and this is how they operate. And I'm always a big argument that you got to be careful what you bind yourself to legally, because it may come back and haunt you in the future. So I'm just going to really conclude this. I'm going to go right back to the beginning with John Locke and Hobbes. The idea of lawfare is really kind of a combination of both Hobbes and Locke. In other words, John Locke saying, okay, this is the rule of law, but Thomas Hobbes saying, you know what, and I'm basically saying, the international relations are the law of the jungle, so I'm going to apply, if I have a law, I'm going to apply it to my advantage, and if it really detriments me, I'm going to ignore it. In other words, the rules don't apply. And I'm just going to ignore it if it gives me a strategic advantage. So understand, there's always those two contradictory things. People ask me, what do you think? Is the world Hobbesian or is the world Lockean? I think it's a little bit of both. I think basically there are times when states basically, states always come out in publicly and say they obey the rule of law. They come out in a Lockean principle. However, there's always the possibility and reality that states disregard the laws or interpret them in a way that's an advantage to them if it's going to benefit them in a conflict. So fundamentally, that is a quick and dirty discussion of lawfare. It's really a complex topic. I've given a lot of thought to this. Probably over the past couple of years, I've really started thinking about this a lot. If you subscribe to my briefing letter, the Pressy, I have a whole section dedicated to lawfare. So again, this is just a warm up, basically a precursor to outer space. And in the next video, we will talk about lawfare as it's applied to outer space. And lawfare has been really applied to outer space for actually since the beginning of the space age, and in some very interesting ways. But I hope to get that out in the next week or so to you, and we will discuss it then. It will probably be a lot shorter than this video does. I encourage you to subscribe if you're not a subscriber, and definitely like the video and share it to get the word out. And I hope this video is a little bit helpful to explain what is really kind of a complicated topic, and really, in my opinion, a very opaque and very subjective topic as well. So until the next video, we'll talk to you then.